Welcome back to a new episode of Reed Smith's Arbitral Insights. My name is Andrew Tetley. I am a partner in the Reed Smith Paris office. I am joined for this podcast by Clément Fouchard, who is also a partner here in our Paris office, with both of our practices focused on arbitration. Today, we are delighted to welcome Claudia Salomon, President of the ICC Court of Arbitration. Claudia needs no introduction. She joins us on Arbitral Insights, not for the first time. We last spoke early in her tenure as president. 5 years later, Claudia has generously agreed to speak to us again. And we're here, hot off the press, to talk about the 2026 ICC rules that have just been delivered to the arbitral community. Thank you, Claudia, for affording us this opportunity, and we look forward to our conversation.
Thank you so much, Andrew. Thank you, Clément, to Reed Smith, and really glad to talk with you.
Okay, so hello, Claudia. Thank you again for taking the time. A few days after the release of the new rules, we have a few questions for you. Obviously, being at the center of the revision process of the rules. So we'll start with perhaps a very obvious question, which was what drove the ICC court to update the rules now, and what was the consultation process like and the reception so far? Maybe if you can tell us a bit about that.
Certainly. We really had a few key goals when we were thinking about revising the rules. The first is, of course, to ensure that the ICC maintains its leading position as the most preferred arbitral institution in the world. We also wanted to make sure that the rules reflected the changes in practice and law, that we were meeting the expectations of the parties that really are rapidly evolving, especially around technology, that we were focused on efficiency and focused on clarity. So this process began about 2 years ago. And I want to emphasize it was not a backroom discussion or negotiation, but really a very open consultation process. We sought the views of the Global ICC Commission on Arbitration and ADR, which has 1,400 members. Also, the input from almost 100 ICC national committees from around the world. Not once, not twice, but multiple times, including 2 years ago, just the open call for any idea that anyone in the global ICC community had regarding the ICC rules. And I also should emphasize that we really sought the input of in-house counsel, and their particular perspectives really shaped the revisions.
Thank you. That's excellent background for us to start. If we can move in, we're going to go to some more specific questions to try and sort of eke out the sort of thinking behind the changes. And one of the changes that we noticed was that a number of the changes in the rules involved bringing into the rules what had previously appeared in the note to parties. I'm thinking here of the arbitrator disclosure provisions and early determination, which were in the rules, in the note, and are now in the rules. What's the thinking behind that? What prompted that?
Yeah, I really have focused on what I would call transparency 2.0, that parties can read the ICC rules and really understand how ICC arbitration works. Now, of course, the rules are not a treatise, and we cannot include every element. So, for example, the full meaning and context of the words independent and impartial with regard to the duties of arbitrators are not explained in the rules themselves. But if there are particular elements that are key to the way our arbitration and ICC arbitration works, then we wanted to include those in the rules themselves. And so that's really why we moved some of the provisions from the note, which is really to provide guidance with regard to how ICC arbitration is conducted, into the rules.
Thank you. That all makes perfect sense to me. Let me turn to the sort of perhaps headline change that has been picked up by the various commentators. The decision to remove the mandatory terms of reference. Now, this concept has existed since the first edition of the rules in 1922. I think it was then referred to as the form of submission in those days. But it's an apparently major departure here after 100 plus years in the new rules. Are terms of references doomed to disappear, or will the procedural function, perhaps, of the terms of reference be displaced, perhaps, into PO1?
So I really think the terms of reference have outlived their utility. Sometimes I ask people, why were the terms of reference actually first included in the rules more than 100 years ago? And they were there because there were certain courts around the world that did not recognize as enforceable what we know as an arbitration agreement, where parties include in a contract a provision that disputes that arise in the future will be resolved by arbitration. That was not something that was recognized as valid. And so there was an actual need when there was a dispute for the parties to expressly identify what was the jurisdiction of the tribunal, the specific terms of reference, which in almost all instances is actually the arbitration agreement, unless there's a lack of clarity around that. And so we have maintained the terms of reference. In some ways, many people have thought we've kept it because it was a defining feature of ICC arbitration. But I certainly didn't want to keep something that didn't have a good function. So now, with regard to the terms of reference, I should emphasize that the expedited procedures, which have been in place since 2017, do not have the terms of reference. We've had over 1,000 cases under the expedited procedures. And what we have seen is when parties and arbitrators think they would be useful, they have gone ahead and adopted the terms of reference as a case management tool. And so the terms of reference are still available if parties and arbitrators consider them to be useful. What's important for everyone to understand now is the first case management conference now has a very important function, as it does under the expedited procedures, which is that is now the cutoff for new claims. So parties need to be focused on articulating their claims and defenses before that case management conference. And again, if there are things that they would like to include that would have been included in terms of reference, those can be included in, for example, an agreed or signed PO1.
Good, thank you.
Claudia, I would like to now cover another topic, which is the emergency arbitrator rules. And the new rules do contain some changes in this respect. So under the new rules, emergency arbitrator proceedings may be initiated against, and I will quote, any party for which the president is satisfied based on the information in the application that an arbitration agreement binding such party may exist. And that's the Article 1(2) of the emergency arbitrator provisions. What issue is this new provision addressed to, and how will it operate in practice, according to you?
This provision is really designed to reflect our practice, because the 2021 rules, had that the emergency arbitration provisions applied to signatories or their successors. But the president of the court makes the decision about whether the EA provisions apply. And there could be certain circumstances where we don't have an actual signature, but there's all the indicia to demonstrate that, in fact, the responding party has signed the agreement. And in such circumstances, myself and my predecessors have, in fact, determined that the EA provisions apply. And then if there's jurisdictional objections, those can be addressed by the emergency arbitrator. So, in fact, this language was designed to basically reflect the existing practice, but not necessarily change the way in which it was functioning.
I see. So it's really a very good example of transparency 2.0 you were advocating earlier. Another question in relation to emergency arbitrator. For the first time, ex parte applications may be made for preliminary order, and that's Article 7.1. As we know, the ancestral model law was first mover on this. That was a 2/6 amendments. So what prompted the change for the ICC now in 2026? And do you anticipate any use or heavy use of this new provision?
So really the change was sparked by two elements. One is to reflect practice, because this is something that has taken place in the past. But secondly, we really heard significant calls from the arbitration community that it was inconsistent with our goals of enabling the emergency arbitration process to be a true alternative to the courts when we didn't have this element expressly included in the rules. Whereas in some courts and in many courts around the world, parties can in fact get ex parte preliminary orders. What we did with regard to this provision is include the language that such a request could be made when a party is seeking an order directing another party not to frustrate the purpose of the application. So it's there to, in essence, make clear that if communication about the application in and of itself would frustrate the purpose of the application, then such an ex parte order could be requested. We've also really sought to ensure that due process is protected. And in that respect, the preliminary order is only in place until the emergency arbitrator makes a decision with regard to whether it should be maintained, and the Secretariat transmits the request together with the application and the preliminary order to the responding party right away. I should just add additionally, the language also expressly says that if the preliminary order is granted, the emergency arbitrator must immediately afford the other parties the reasonable opportunity to present their case. So that's really the additional due process protection.
Thank you. Very, very clear.
Ex parte inside arbitral process has always been a stickily tricky subject, but it's good to see that this provision's there because it is responding to a practical need for sure. Turning to another innovation, and this is an interesting development certainly, is the new highly expedited arbitration provisions, which are now feature in the new rules. Singapore SIAC has offered this in its new rules or something similar in 2025, but in this case with the ICC, as I understand it, the scrutiny process will still apply to heap awards. How can users of ICC arbitration take advantage of heap? What does this offer to them, and how do they take advantage?
So let me emphasize that I really think the ICC highly expedited arbitration process is quite different from what SIAC is offering. Notably, SIAC's provision is really geared for disputes below 1 million Singapore dollars. What we've sought to do is really think through the process to ensure that a final and binding award could be issued regardless of the amount in dispute when the parties opt in. So first of all, it's only an opt-in process, not based on the amount in dispute. The initial substantive submissions are also really front-loaded. There's express provisions that provide that the request for arbitration also needs to include the statement of claim. The answer also needs to include the statement of defense, that there is no joinder or consolidation possible. There are other shorter time limits. We do provide that the case is decided by a sole arbitrator. And if the parties can't agree within 20 days, the court will make that appointment. So what we've tried to do is also make sure that the process for getting a sole arbitrator appointed is also faster. There's two other provisions to highlight. One is, like with expedited procedures, the arbitrator has discretion over the proceedings. In other words, to decide whether there should be document production or a hearing. But also what's really unique about the highly expedited procedures is the parties may agree on an unreasoned award. It doesn't mean that every highly expedited arbitration process will have an unreasoned award, but the parties may in fact expressly agree to that. I would emphasize that it actually took us quite a long time to draft up these provisions. And the reason I'm telling you that is that when we see parties just provide a very short time limit for arbitration, it's often not functional, or it often is pathological because the provisions don't really work. And it's very, very difficult to get a final and binding award within such a consolidated time period. So what we've really tried to do is give parties the tools that they need if, in fact, they want a quick process and a quick final and binding award, that they don't need to draft up the arbitration process in some ad hoc provision, but they can just adopt this whole cloth.
Thank you. And we discussed internally the potential of the highly expedited arbitration procedure, and really giving back to the parties and the council the possibility to draft an opt-in clause using and leveraging as best as possible this new feature. So that's quite exciting for council as well, I must say.
I think there'll be quite a number of situations where parties may want such a fast process, not just for low-value disputes. It could be purchase price adjustments. It could be disputes involving rapidly changing technology where they really need a final decision.
Absolutely. Then the next question relates to the changes to the ICC rules which were left on the cutting board, whether any innovations that was maybe not ripe, not ready to be included. And before you answer, Claudia, I want maybe to share some thoughts. I have one example, which is artificial intelligence. As we know, its presence is growing in dispute resolution, whether in document review, legal research, or even certain aspects of the decision making. And we know, of course, that the ICC working group is on AI is already examining those issues, but wanted to know how should the ICC address the rise of AI through soft law instruments or binding rule provisions. And so that's just one element I had in mind, which is obviously will be the subject matter of future discussions.
Well, I'll start with saying that there were quite a number of things that were proposed that we decided not to change. And so it wasn't that we didn't change them or add them because we hadn't thought them through. So I would say I'd put disclosure standard in that category. There was a lot of discussion about whether to change the standard because ICC has a much higher disclosure standard than other arbitral institutions. And we heard a resounding voice from the arbitration community around the world that they valued the higher standard that ICC has. And so we kept that the same. The same with regard to whether there should be a award rather than just an order. And we made a very specific decision not to make that change. And I would say that's the same for whether to include anything in the rules regarding artificial intelligence. So some people said, well, you need to include something so people don't think you're being retrograde by not including it, that quote notable absence that you've identified. And to me, that was a really bad reason to include something in the rules. What we have is the ICC Commission on Arbitration and ADR having created a task force on AI and international arbitration. So they are examining closely in this first phase whether any guidance needs to be provided to arbitrators with regard to the use of AI, with a report for approval by year end. So we wanted to ensure that the rapidly changing issues were actually carefully considered and decided and to allow the task force to carefully consider these issues, and made a decision that this wasn't for the rules themselves, but to provide guidance. And you'll note that we have taken out the case management techniques that were previously in Appendix 4 and now included those in the guidance note. And we also made an assessment that similar issues related to ethical obligations are more appropriate in guidance rather than in the rules. So I don't consider this to be an absence in the rules, but actually an ongoing process, and then we can provide guidance as appropriate.
Thank you, Claudia. I think that that addresses really the point. A question from me again, maybe just wrapping up a little bit on that. What are, according to you, the most important changes for users? And what should also practitioners and in-house counsel be doing right now with the new rules in hand?
Let me emphasize 3 points. The first is at the time of drafting the arbitration clause, just like parties should be considering whether they want litigation or arbitration in the first place. Do they want confidentiality? What is the governing law? What is the place of arbitration? They should also really be considering, do they want an expedited process? Do they want a highly expedited process or regular arbitration? We are hearing from parties around the world that they are opting into the expedited procedures, even when the amount in dispute is much higher than the default provision. And so that's something to really think through. Expedited and highly expedited arbitration is not right for every case, but it's really something parties should consider. Secondly, under the new rules, parties have the obligation to disclose relevant entities and individuals at the time of their initial pleadings in order to assist arbitrators with their disclosure obligations. And so that is a key practice point that everybody needs to be thinking about. And the idea here is, again, to assist arbitrators. We have added a requirement that the parties state the reasons for including the names of these entities and individuals to try to minimize the risk that these lists would become weaponized. The third practice point, I would say, is that everyone needs to be aware of the important role of the initial case management conference, as we were discussing with regard to the elimination of the terms of reference as a mandatory step in ICC arbitration, because that is the cutoff for new claims. And maybe a bonus point I would add, which isn't specifically about the new rules, but also linked to the elimination of the mandatory terms of reference, is I would say that everyone, practitioners and in-house counsel and arbitrators, should really be focused on the issues to be decided throughout the arbitration process. Of course, that was an element of the terms of reference. But we know most parties did not actually grapple with the issues to be decided in that early stage of the arbitration. So it's something parties should be grappling with at the beginning, after the first round of submissions, before the hearing, and at the end of the hearing.
Thank you, Claudia.
I'm going to shift off the subject now, Claudia, if you don't mind. And so we've had a very good run through the new rules, and that's been extremely helpful for our listeners. But I'm just going to ask you a much broader question now, because you've done the rules, they're updated, they're revised 2026. What is the ICC's next objective to improve the user's experience? What's next in the pipeline?
Every element of my presidency has really been focused on international arbitration with a client mindset, making sure that we are focused on the needs of the parties. And so I would say, as in the last year of my presidency, we're going to continue to do that. And that is also to ensure that the service we provide is really focused on meeting and exceeding the needs of the parties, and that our technology tools currently with Case Connect powered by Opus 2 is really continuing to improve. And as we continue to get feedback from the parties and the practitioners and the arbitrators, we are continuing to make changes. We also need to consider and build on our thinking about what additional tools we might seek to offer, particularly around low-value disputes to meet the broader mission of the International Chamber of Commerce, which is focused on access to justice and rule of law. And I would lastly highlight that in connection with thinking about the tools for parties, it's not just in connection with dispute resolution, but also in connection with dispute prevention. And next steps will certainly be revisions to the ICC mediation rules and other ADR provisions.
Thank you, Claudia. And I think with that, we will wrap up, and I will pass it to Clément, who to do the final words. But for my part, thank you very much for your time today.
Well, thank you, yes, for very clear answers and also the insight and perspective for the future. Well, the takeaway, I mean, I've listened the podcast of June 2021 again before recording our session today. And you underlined the importance of having the clients more engaged with the ICC arbitration, let's say. And I think that the new rules are actually reflecting on that objective, thinking about the importance of drafting HIP opt-in clauses, the related parties list that should be very much into the parties' hands. Early determination, we did not mention that, but that's not necessarily an entirely new feature, but something that the parties will be able to probably use more. The CMC, I mean, that reflects this general trend and maybe reflects on your presidency more generally. So again, thank you, Claudia, and taking some time with us today.
Great. Thank you so much.
Arbitral Insights is a Reed Smith production. Our producer is Shannon Ryan. For more information about Reed Smith's global international arbitration practice, email arbitralinsights@reedsmith.com. To learn about the Reed Smith Arbitration Pricing Calculator, a first-of-its-kind mobile app that forecasts the cost of arbitration around the world, search Arbitration Pricing Calculator on reedsmith.com or download for free through the Apple and Google Play app stores. You can find our podcast on all streaming platforms, reedsmith.com, and our social media accounts at reedsmithllp. This podcast is provided for educational purposes. It does not constitute legal advice and is not intended to establish an attorney-client relationship, nor is it intended to suggest or establish standards of care applicable to particular lawyers in any given situation. Prior results do not guarantee a similar outcome. Any views, opinions, or comments made by any external guest speaker are not to be attributed to Reed Smith LLP or its individual lawyers. All rights reserved.